My name is Reyno De Beer, Liberty Fighters Network. Today is the 9th of July 2020, just after 3 o'clock in the afternoon. The reason why I'm making this video is that I've received and our executive received so many phone calls and emails and WhatsApps and SMSs from members of the public wanting to know from us what is now going on. What is the purpose of your judgments? Because we don't see anything happening. So why did you actually go to court? What's going on? And what I've noticed was that there's legal experts in this country who are teaching other law students at universities, but they don't know the basics of interpreting a judgment. When they are phoned on radio or interviewed for a news article in the media, they go out and they've got so many things to say. They said in the beginning that leave to appeal will be granted on the basis that the court order was not specifying anything specifically, blah, 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 blah. For that, they hypocritically only utilized the judgment and the reasons for judgment. But now, when it comes to the leave to appeal application, for which we have received a judgment on the 30th of June, now they want to take everything, all the records, and try to interpret everything. And let me teach you the basics of interpreting a court judgment. A court judgment consists of two parts in most instances. It's the reasons for the judgment, and then you've got the judgment itself. Now, the court order part. Now, the only relevant part of this whole judgment is the court order. That is the part and the only part that needs to be interpreted. And unfortunately, now these legal experts that we are looking up to, and I myself is legally ignorant. I've only managed without legal qualifications and to be a legal practitioner myself to successfully obtain judgments against the government. Nothing serious, but now these people want to tell you that we still have 10 days left. The court order says that there are still 10 days until the government can make up their minds whether they want to or don't want to further appeal or blah, 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 blah. Now, let me go to the basics of interpreting a court judgment for you as the members of the public to understand. For that purpose, I would like to refer you just quickly also to another Supreme Court of Appeal judgment. There are actually several of these, but this one is very interesting, this one is quite clear. And this is and the Supreme Court of Appeal is obviously in the higher degree as the High Court, so the High Court must follow the Supreme Court of Appeal, just like the Supreme Court of Appeal must also follow the Constitutional Court, which is ultimately our apex court, our biggest or the highest court in South Africa, on constitutional matters, but also on matters of general interest. But let me get to the Supreme Court of Appeal judgment here. This is a matter in between Athol Developments versus the Valuation Appeal Board for the City of Johannesburg. This took place in 2015. It was reported on page 55, and the judgment was given on the 30th of March 2015. Okay, now what the Supreme Court of Appeal, it was 1, 2, 3, 4, 5 judges who made this ruling. On page 6 at the bottom, they've referred to another court case, also Supreme Court of Appeal case, but they've basically confirmed this again 5 years ago, and this is still valid. It says that when a judgment has been delivered in court, whether in writing or orally, the registrar draws up a formal order of court which is embodied in a separate document signed by him. It is a copy of this which is served by the sheriff. There can be an appeal only against the substantive order made by the court, not against the reasons for judgment. Now, what this means is that the reasons for judgment, you cannot appeal. It's not part of the order. What is important is the court order itself. Everything that the court wanted to have embodied into this whole judgment should have been mentioned directly in the court order itself. So when you go to the judgment of the 30th of June, that is the second judgment, you will read through it. I've taken the court orders. This is the court order. This is physically the court order. So I've laminated it so that I can carry it with me wherever I go to show people that this is the court order. Especially to police officers who don't know what the law is. And in this court order, when you read it, there's nothing mentioned of 10 days. Nothing. So, when you go to the first court order, which was delivered on the 2nd of June, all of these, by the way, these judgments can be obtained directly from our website, www.libertyfighters.co.za. Now, when you go to this one, when the court declared the lockdown regulations as unconstitutional and invalid, in this one, the court was given 14 days, or the Minister of Cooperative Governance and Traditional Affairs, Dr. Dlamini Zuma, was given a period of 14 days to rectify these lockdown regulations and bring it in line with the Constitution. And if that 14 business days from the date of this order comes to pass, then it means that the invalidity and the unconstitutionality or the effects or the operation thereof will then kick in. So when you take the 2nd of June and you read that judgment, the original one, you'd realize that 14 days from the 2nd of June, 14 business days would have lapsed on on midnight, the 23rd of June. That is when the time that was given to the minister to rectify all this crap had to cease, and meaning that is why we went out on the 24th of June. We went out and told everyone, and it was well within our rights to do it, that the lockdown is essentially over. based on the reason that the 14 days, according to other law and court cases and everything that we have studied, we have concluded, in our view, that the 14 days ended on the midnight, the 23rd of June, hence the reason why we said that the lockdown was technically over, because there were no lockdown regulations in place according to us on the 24th of June, implying excluding certain, there were approximately 6 regulations that were specifically excluded, and I will deal with those regulations in a separate video just after this one. But my purpose is just now to explain to you what this actually means. Now, when you now they are saying that Section 18.1 of the Superior Courts Act of 2013 says that when a person files an application for leave to appeal, the order is then suspended. The execution and the operation of that order is then suspended. That is in terms of sections 18.1 and read with 18.3 of the Superior Courts Act, when where people make that interpretation. However, what we said was that the 14-day period, for purposes of declaring a law as invalid or unconstitutional, the 14-day period was fixed in terms of the Constitution, which is our supreme law. It's the Supreme Act of this country, and in terms of Section 172 of the Constitution, that period is set by the court itself, and not in terms of any other act. So that authority is given to the court to give us that period. So now the situation was that they said, but the 14 days was interrupted by the leave to appeal application, because they filed it 5 days within after the second. So they filed it, I think it was on the Monday or so, but it was 5 court days. So then there were actually now 10. Okay, the court came to another academic calculation, but according to us, there were actually then 9 left. But the fact is that you cannot give that task to determine these dates to the man in the street. You must give that to the court, and only the court. We are saying that the judgment that was laid down, or the order that was given on the 2nd of June, basically says that it was only certain regulations, 36, 38, 39, 2D and E, Regulation 41 were of alert level 3, were excluded from that order. And also, unfortunately, the one, and I'm reading this because this is very important, the regulations pertaining to the prohibition on the sale of tobacco and related products is excluded from this order and is postponed sine die pending the finalization of case 21688 of 2020 in this court. That was the FITA case. Okay. Now, what we are saying is that the court, on the 30th of June, the court granted the government the right to leave to appeal on the basis of the blanket or the overall regulations. But in paragraph 2, with no indication of any time period given, have said that leave to appeal the remainder of the judgment and orders, including leave to appeal against the declaration of invalidity of those regulations mentioned in the judgment, being regulations 33.1e, 34, 35, 39 2m, the exception to regulation 46.1 and 48.2 is refused. The problem everyone is now having is the confusion about regulation 48.2. Okay. 48.2 is a very, very interesting regulation and embodies the lockdown regulations, because that is the regulation which is actually criminalizing these certain lockdown transgressions, inclusive of the sale of alcohol and the sale of tobacco. So according to us, this court order confirmed that those regulations, in particular regulation 48.2, is unconstitutional and invalid. And then the Constitutional Court has on many instances said that the Constitution of South Africa is the supreme law of this country. Any act which is not in line with the Constitution is invalid and unconstitutional. It is not only invalid the moment when it is declared by a court as being invalid. It's invalid the moment when it's in contravention of the Constitution. Meaning that now the police is sitting with a major problem. And that is what we are trying to highlight to everyone. You cannot be found guilty of an offense, a criminal offense, if you did not have an intention to break the law. If you believed as a reasonable person that this court order dating the 30th of June said that it's unconstitutional to criminally prosecute anyone for violating those specific regulations. You cannot be found guilty in a criminal court because malice or maliciousness cannot be proved by the state. That is the key question, because we have gone out and we said that all these lockdown regulation transgressions, criminal prosecutions, are dealt with in the magistrates' court. The magistrates' court must listen to the High Court. If a High Court order says that regulation 48.2 is unconstitutional and invalid, it's invalid the moment when it was made, not the moment when it was declared. Remember that. If any police officer is now going to come and arrest someone who is selling liquor, for example, at his premises, and in terms of regulation 48.2, that is then seen as a transgression, a criminal violation, or very importantly for many, if you are called to find to sell tobacco, the authority of the police is no longer there. Regulation 48.2, which is invalid from and since it was created, way back in, that specific regulation came into operation, I think, way back in May, with the latest change, or with the previous latest, I think 28th of May, yes. So, since then, when it was made, it was unconstitutional. It was not in line with the constitutional and therefore invalid already. So now, unfortunately, what is happening is that for some odd reason, and due to the fact that these legal gurus in South Africa have gone out and they have told the public, no, you must wait for 10 days. There's no 10 days in the court order. If it's mentioned, or the 10 days mentioned still in the body, in the reasons of judgment, that is purely for academic purposes. You cannot take that, or if this might be given to a sheriff, the sheriff cannot take that into consideration in executing or putting this into operation. It cannot be taken into consideration because I've just a couple of minutes back I've showed you that the Supreme Court of Appeal have specifically said so. That you cannot take the leave to or the reasons of a judgment into consideration. The only part that is valid is the court order. So let me summarize. We believe that there is reasonable doubt for anyone who goes out selling liquor, selling tobacco, etc., to be created in a criminal prosecution if you are being arrested or prosecuted in any way. That magistrate's court will have to take into consideration that there is a court order that you as a member of the public reasonably interpreted and accepted that it's no longer a crime anymore to do those things. So that is the purpose why we said that selling of tobacco and the selling of liquor on site by a pub, etc., etc., are no longer invalid. Even if the regulations itself might say that you may not, then it's a civil matter. The government must civilly prosecute you, which means that they must first send you a letter to say that you are contravening this clause by, for example, selling tobacco, and give you opportunity to react to it. And if you don't, then they must apply to through a civil process to the court to get an interdict against you, a court order against you not to sell tobacco anymore. The police does not have the authority anymore to prosecute or to arrest you for selling of liquor, selling of tobacco, or contravening any one of those clauses that I will highlight in another video. Please, people, if we don't take and claim our rights that were given to us by the court, this government will not give it to you. It's our responsibility to go and fetch it and claim it. We are busy advocating actively, and it's within our rights to do it. And if the government does not like what we are telling the people, the government must go and get a declaratory order to prove that our interpretation of this judgment is totally wrong. They have, since we have started on the 24th of June, to actively advocate that the lockdown is essentially over. The government has not once reprimanded us. They did not, because they agree with what we are saying. So we stand by our points. There is no negotiation about this. If the government wants to interpret it in the way that these legal experts who have been wrong, let me add, have been wrong about our case since the beginning, if they want to believe these legal experts, they must go and get a declaratory order to how this needs to be interpreted. I've got nothing more to say about this. You are welcome to communicate with us. Go to our website, www.libertyfighters.co.za. You will find a link there. Go and get this order, and yes, let's go and claim our constitutional rights. It has been given to us by the court and by the constitutional from the beginning, and it's just up to us to realize that we are the ones who are governing this country and not this government. The government must listen to the people and not the other way around. Thank you very much. Hope this helped. God bless all of you.